before we start our discussions, we got an email from a viewer last week who wanted to know if you could protect a smell, a sound, or a colour.
Interesting question. Thanks for writing into that viewer. Yes, in principle, anything that is distinctive can be registered as a trademark, and you can get protection for it. The difficulty with those three, let's take, for example, a sound. First of all, it's quite difficult to put it on an application. Can you imagine how to describe your sound in the actual
Can't you
application?
audio tape it?
It's possible. It is possible, but there are other problems with that. The other thing with, let's say, colour, he said it is registrable. A colour, we talked about the colour depletion doctrine last time, and how single colours are difficult to get exclusivity to. And so, yes, anything in principle is registrable. Smells, for example, how can you put smell on an application form? And that's a difficulty with that. If you can't register it, then of course there's passing off, which is a common law remedy for protection of get-up and noises and anything distinctive about a particular product or get-up.
Okay, so take us through briefly the process of getting a trademark registered.
I'd like to use an example, actually. I'm going to talk about Pig Spotter because it's been
yes, so topical right now.
It's been in the news. This chap he's now got 20,000 followers, and he's developed a brand effectively. And I looked on the register before I came on the show, and it's not registered. And that's a problem for him because there's a huge increase in cyber squatting, there's a huge increase in typo squatting, and someone could apply to register it and it's first to file in South Africa, although it is possible to use common law grounds to stop that, but it becomes difficult to. I'd encourage a person to file to register his trademark, but he has some difficulties in doing so. The first is no one knows who he is. So he has to put a name, an applicant, on the trademark filing sheet, and there are ways around that he can use. One is,
but don't you think this is going to compromise his identity?
Well, you see, this is the difficulty.
Okay.
So, for him, and it's not uncommon, the STIG, for example, if one had
Top Gear STIG, right?
Top Gear STIG, okay. So if that individual had to apply for his own personal trademark, he'd have to disclose his name as well. It's owned by the BBC in that particular instance. So, of course, it's registered to BBC worldwide. But in Pig Spotter's case, what he could do is possibly, if, for example, he intends to disclose his identity at some stage, he could apply in, say, in the United Kingdom, and then he gets a 6-month grace period to file in South Africa, and it gives him 6 months where his identity is not really disclosed. It would be difficult to track down. You needn't choose the United Kingdom. But there are other ways he could establish a body corporate that he could intend to license it to, and then apply for it in an individual's name that might not be his own. So there are ways around it, but it would need to be carefully thought out.
But now, isn't it also a bit tricky because it might be seen as offensive, the police are involved? I mean, is anyone going to want to touch this story? Exactly.
I mean, I think that's the other thing, is that when it gets to be examined by the registry, they're going to turn around and say one of the possible objections I could receive is that it is likely to offend a particular class of persons. And that class of persons is not defined, and it could, of course, be the police. Or is contrary to public policy. You know, can we have people going around calling our police force pigs? I mean, that's the question. But what's happening, what seems to be a trend these days is, let's say, for example, FC UK. Swear words, those have in Europe been registered. And what it's meant is that and South Africa tends to follow European decisions. And so it would be a very nice debate, actually, with the registry on whether we could get protection for that. But at heart, it would be, I would think, it just goes against the grain. If the guy's created a brand, it's a risque brand, sure. But to not allow him trademark protection for that brand seems to go against the norms of what the trademark registry is.
Okay, so let's look at what will happen if he doesn't get a trademark.
If he doesn't get one, let's say, for example, he doesn't succeed, or he doesn't even apply for one, and someone else comes onto the register, or someone else gets a domain name or another Twitter account called Pig Spotter or something similar, Pigspot KZN, for example, he would have to first show that he had a reputation in that name and mark, and that it's his. Okay, it has to be owned by someone. I don't think that would be difficult to obtain because, you know, it's of the huge publicity there. And if you look at Standard Bank, actually, for their Moving Forward slogan, they just this week won a domain name case where they were able to show the very next day that they'd established a reputation almost in a single day on the relaunch of their moving forward brand. But that's more the exception than the norm. He would then have to go and show that there was a likelihood of confusion and that people were being confused by the association with a new pig spotter or trading off his goodwill.
Of his goodwill. So that is really the pitfall for him if he doesn't register. So someone else can take it over and trade as if they are the pig spotter.
I don't think they can. But it's a little bit more.
But it can take away the goodwill, like you said.
Exactly, and it's a much more difficult thing to stop because you don't. This trademark register is your title deed to your house, for example.
Right.
It's a title deed to your goodwill.
Yeah.
And when you just have to go and show that to a court, and then you get the advantages of protection under the Trademarks Act, which is cheaper and much more cost effective and much more effective.
So, lastly, do you think you will get the trademark? Yes or no?
Absolutely. If it comes to us, of course.
Of course.